ladies and gentlemen from all over Europe. We were proud to see that many of those SMEs who have taken part in the DIGIBCUBE venture and who have registered on the platform are also taking part today. And so the topic of today is be aware of your intellectual property. Intellectual property is what you have but not yet registered, and intellectual property rights are then those rights which need registration, not covering copyright, which does not need registration. And those intellectual property rights are then prone to protect your inventions and also to secure your business, and for instance with a trademark to give a unique selling proposition with a trademark that is gaining importance by customers' satisfaction. So here you have also the DIGI-B-CUBE consortium, the logos given below. And today's agenda will cover the following topics. So first of all, clearly a warm welcome again from sunny Austria, and hereby also the introduction of the agenda. I will start with an introduction of the importance that intellectual property has, especially also in the field of digital healthcare. Made some searches especially for this workshop on this topic. Then it is followed by some general introduction into intellectual property rights. So how to protect your IP. We will have a short break after 1.5 hours. And I will continue then with dealing with IPR funding options. Actually, this is a topic which has not been foreseen originally, but which was, let's say, a wish of a participating SME. And I have been following this wish and will introduce you with some opportunities how to get funding for your IPR applications. Then the last module is dealing with patenting strategies, where I will introduce you in detail into the procedures, the do's and don'ts, and for instance also the options how to patent internationally. And after that 4 modules, we are giving you the opportunity to give us an important feedback using Mentimeter, and this will then be used also for us in the project. But we will have a second input in Mentimeter, which you all will see. This will be a word cloud. And after that, I will be eager to answer all the questions which you have posted in the chat. So some housekeeping is, please post questions only in the chat. Please turn off your camera and also your mic, because we would like you to only use the chat for the questions, but your questions will be taken up and depicted on a PowerPoint slide by my colleague. and I will then answer them one by one. And if it takes some minutes longer, I will be eager to answer all your questions. So with that, I would like to go to the first topic. And this is intellectual property in digital healthcare. So I start with an overview or with some table and graph on the European patent applications in 2020, showing that healthcare innovation is a main driver of European patent applications. So you have in the top 10 fields for patent applications, in number 1, you have medical technology, directly followed by digital communication and by computer technology. And all three are, let's say, in most cases involved in digital healthcare. So you see the importance is really preeminent, and you have to take care, first of all, also about the patents of others, which you even may violate. And this can be, let's say, checked by patent searches done by yourself or by an external expert. For this topic of patent searches, I invite you already, those who have not yet signed in, to the second IP webinar in December, where I will deal with patent searches using free and very comprehensive services from the European Patent Office, especially the new Espacenet. So I will introduce you to that in this second webinar, and I will also give hints, but also then you will get some exercises and try it out on your own. So the next thing, and here I have to say some of these topics are maybe a bit too detailed for you in the moment, but I want to just shed a light on the importance of intellectual property in digital healthcare. So one preeminent topic is cybersecurity challenges. You may be aware that cyber attacks are nowadays done here and there and everywhere, especially at larger companies. And in the field of medical technology, it's even worse if you, for instance, block a big let's say, healthcare station by cyber attack. This is really a thing not to imagine best. So here you have some more topics. I don't want to go in detail with them, but just a bit also. I mean, these are general trends, but they are also always followed by patenting applications. The one big trend is consumers are more and more in control. And if you offer devices and methods and software that consumers are more and more in control with medical technology and digital healthcare, this will help a lot. There is also a trend that virtual care will grow, and also this is accompanied by a lot of patents which have been already applied and granted. There is this trend that hospitals get smarter, considering also GDPR, so you have to take care of privacy issues, but still that this is something which will get more and more important, and will also use a lot artificial intelligence developed then. So legal issues to consider, again, cybersecurity, data privacy, registration requirements, liability, and market access. And especially cybersecurity, I will not go into detail here, but you can read it afterwards. You will get the presentation in electronic form, and the whole presentations are also then recorded and then saved on a YouTube channel, and you will get the link to that, so that either colleagues of you can watch it, or if you want to have some repetition of some parts, you can do it like that. So ransomware attacks are an issue in digital healthcare, which you have to take care of. And if you offer good technical solutions how to cope with that risk, you are definitively better off. So another big trend clearly is digital healthcare incorporating artificial intelligence. Most of the time I offer you links to that to see the original articles, and here is then a screenshot. So you have a lot actually of patenting digital health innovations incorporating artificial intelligence, especially in the US, but it is more and more also spreading to other countries. We have some limitations due to European patent law, but a lot is possible. I will tackle this then in a moment. So here there is an article on recent subject matter eligibility guidance. In short, this means what are the criteria for patenting artificial intelligence in this application. So to give you some insight on the dynamic development of patents in digital healthcare, which are related to artificial intelligence, here is this trend. For in blue are US patents, and in orange you see the even more prominent published US and PCT applications. So patents mean this is already granted, and the other things are applications which are either done nationally in the US or via PCT, which I will deal with later, is a method of international patent applications or spreading your own national patent to the world. And here you have even bigger number, which is, let's say, then always with a bit of time delay, it corresponds then to also to granted patents, but not all of the applications are granted clearly. To understand the graph, 5-year bins are here depicted. So a summary, for instance, of all the patents from 2016 to 2019, so-called 5-year bins, and which is a summary. So you don't have every year indicated, you have the sum of these last 5 years here indicated in 2019 point, for instance. Yeah, then I would like to switch to a patent law which is a bit stricter regarding artificial intelligence, but even here you have a lot of options, and there are a lot of patents out there based on artificial intelligence dealing with digital healthcare. And so here you also have a link which you may follow if you are interested in some details. But in general, you may say that the German Patent Office, for instance, as an example of many other European patent offices which deal with it in rather the same way. So when they examine the patentability of AI inventions in the digital healthcare field, they use a three-step approach, assessing first of all the technical character of the subject of the invention. So it always has to be a technical invention. Secondly, they check whether the patent claim contains instructions for solving a specific technical problems by technical means. So below you see abstract ideas, including mathematical methods, are not patentable. So you have to provide, on the basis also of some theoretical concept and artificial intelligence, but you have to provide detailed instructions for solving a specific technical problems by technical means. This is also then called technicity. And clearly, the third criterion is also of utmost importance. The claimed subject matter has to be new worldwide and no publication of that before, and it has to be inventive over the state of the art. So what is quite often discussed is whether something is really inventive, even if it's new, whether it is also inventive, or whether an expert in the field who gets such a target of development is not also able to do it just on the basis of his expertise without needing an invention. Then digital health technologies often pertain to computer implemented inventions. So this is the term which is always used here. Not so much software inventions, it is computer implemented inventions. So this also expresses that, okay, a computer, a software implements the invention, but the topic of the invention is not within the software. The topic is how to really solve a specific technical problem by technical means. And if your subject matter, if your invention, if your whole range of activities and products and so on is maybe not patentable, there are a lot of other IP rights relevant for digital health offerings. First of all, copyright is something which you anyway get without registering somewhere. You just have to have some proof that you have done this at hand, but then it is protected just by making it, just by setting it up or doing it. Then you have design rights, so which have better to be registered. You have some grace period of 1 year where you have it already, for instance, shown on an exhibition or in a presentation, and you can then use this 1 year to decide whether it's really relevant to apply for it, and then you can do this within this grace period of 1 year. And design rights are quite often used also, for instance, if you think about digital healthcare, and you think, for instance, about some graphical user interface which has a very specific appearance, not just one of many, but very specific. And then you can also protect this as a registered design. And this also gives you a leading edge and sometimes an additional unique selling proposition. Clearly, you have know-how. This is something which should be dealt with tacitly. So there is this tacit know-how which you don't tell, but which is quite often very helpful and very important for you. And if it fulfills some criteria, this secret know-how can also be a trade secret. For a trade secret, you have to define what actually is secret about it. It should also be significant and useful and described in a sufficiently comprehensive manner. Then you can protect this as a trade secret. And the European Union, for instance, has in the last years defined a lot about trade secrets, and also is giving some guidelines on this. So in the next step, I have searched for some patent example for digital health. Clearly, I don't want to go into detail with that, but maybe it's interesting for you to follow the link for even more details, or to look at this overview. And so here it is about digital healthcare, digital health ecosystem. This is a patent which is rather new. It was applied for 3 years ago, so you don't yet have a decision whether it will be granted or not. A second example here, we know that it has been granted. This is a European patent. The B numbering shows that it has been granted. It has been applied some 5 years ago, and it is about an electronic system or a software which can deal with a lot of patient data without always using the highest possible resolution. But still you have an artificial intelligence checking, are there any peculiarities, any special features which are not normal? And if this is detected, then the signals are taken with a lot higher precision or data rate, and it can be followed then easily. So this is an example of something which has also been applied for as a European patent, and can then be extended to, in total, I will show it later in another module. In total, up to 44 countries can be reached with a granted European patent, but normally it is validated and thereby nationalized, which is necessary to nationalize it, only in fewer countries, quite often some 4 to 8 maybe. And typically the big economies like Germany, France, Italy, and Great Britain, which is still also a member of the European Patent Convention, although not of the EU. Yeah, so this sums it up what I have especially looked for and searched and established for this IP workshop. So the peculiar features of IPR for digital health. And as in other modules, you have here my contact information. So if you are, first of all, this is a precondition for the direct coaching, for the bilateral one-to-one coaching. If you are a beneficiary who has received a grant from DIGIBCUBE, you are eligible for receiving a very detailed IPR coaching adapted to your very needs. So for all beneficiaries listening, I can only invite you to take this opportunity. Normally, you would pay quite a lot for such qualified IP coaching. So this sums it up, this module. And I will then now go to the next module, which is intellectual property, how to protect IP. So topic is how to protect IP, and this is also a more general introduction of the most important intellectual property rights. So you have, at first I offer you some introduction to the intellectual property rights, then an overview of industrial property rights, because you have to distinguish between general intellectual property, which also covers, for instance, copyright, and industrial property rights, which are only those registered intellectual property rights, which we will cover just afterwards. So these industrial property rights are, first of all, patent for technical inventions. You have sometimes also kind of a smaller restricted patent type of IPR. This is the utility model. And I will show later what are the differences between patent and utility model. Then I will change to design patents, as it is called in the US. In Europe, you rather call it registered design, because it has nothing to do actually with a patent. But in the US, they do not only call it design patent, they also store all the design, the registered design as design patents in the patent database. And then finally, I will cover the very important intellectual property right of trademarks. I will show you which kinds of trademarks are available, and also some brand rankings, which may be interesting for you. So the intellectual property in general is every right arising from an intellectual creation. For the definition of an intellectual creation, it is important that it must not be an objective product. So it has to be something more of in the range of ideas, of inventions, of music composition and everything, but not an objective product. And the very important precondition of intellectual property is that it is new. So no imitation. If you consider how books have been copied by monks in the Middle Ages, this was clearly nothing new. They made beautiful imitations and thereby increased the number of issues of these books, but it has not been new. Whereas if nowadays somebody writes a book on his own, in the moment where he writes the book, it is already protected by copyright, irrespective of it, whether it is very easy to sell it, whether it's commercially viable or successful. It has got the copyright just by the process of writing it. The same holds for music compositions, for manuscripts, but also for design, logo, inventions, books, and commercials, even short signation melodies, they can be considered as an intellectual property. So now I would like to introduce you step by step into how modern products are actually protected. I have to make some disclaimer here because all of you will say, what what very old-fashioned kind of phone is this, of cellular phone? It's maybe, yeah, maybe it can already be called a smartphone, maybe not. The reason behind why I don't take a picture of a most modern iPhone 12 or so is that these pictures are also protected, and that you have to have a permission to use this in such a setting. And therefore I used a source which I have access to, and which has been part of a larger EU project called IP4Inno. And in this realm, the copyright has been clarified and it can be used. So first of all, you have design protection, either by design patent, if you consider the US case, or by registered design, as it is called in Europe. So the protected registered design is, for instance, here this slider phone, how this looks like. In design protection, you always have to think in that way. You can only protect what you can show with photos, maybe from different angles. So a number of photos from different angles for 3D objects, but you cannot protect an inner structure, in a contained technology. And so with design protection, you can just protect what can be seen by the eye and also documented by photographs. Then clearly you have trademark protection, and this covers quite some issues normally. Clearly, also the company Nokia has at that time been using a trademark Nokia, which cannot be copied clearly. I mean, nowadays Nokia is not really producing so much smartphones anymore, but their position in the market of patents is very, very strong, and because they have a lot of patents in the 3G, 4G, and 5G technology, and this is nowadays very important. So furthermore, you have copyright, like software, like ringtones and pictures. You can imagine a lot of such things, but you also have normally you also have patents on technologies, for instance, for manufacture and for operation. I have already mentioned that the highest number of patents around smartphones is actually on the wireless communication technologies like 3G, 4G, 5G. And I have just yesterday followed a very interesting presentation of a Linz-based as institution, SME, which makes big dive into 6G and which is based on radar waves. And so there is a lot to be expected also in the future. And then you also have secret know-how. There is a lot of technical know-how which is not disclosed, which is not published, which is even not patented due to whatever reasons, either because it is not easy to get a patent for it, or because others would learn too much from a disclosure which is always following a patenting. After 1.5 years, everybody can read the details, and patents have to be very detailed because the examiners always check whether the detailed information in a patent description is enough for somebody else to reproduce the effect, or to manufacture the article, or to use this process for his own or her own. So therefore, patents are a very detailed technical description, which is very valuable. And if you are not able to check that others are violating it, then you should better not patent it. Okay, so from this introduction, what one phone, especially cellular phone, or nowadays smartphone, which nowadays will have even more patents. For instance, nowadays smartphones are, let's say, taking the lead also in photography. And there are a lot of innovations how to bring the optics into such small dimensions and so on. And this is another thing which is definitively heavily patented. So here an overview of industrial property rights. We have already mentioned that patent and utility model both protect a technical invention. If you want to provide products or services, or the company kind of a unique selling proposition or labeling, then you can use a trademark. So trademarks, as I will show later on, are very often the most precious intellectual property right. They have the highest value, but this clearly is not just produced or not just initiated by registering the trademark. You have to fill this trademark with good notions, with good experiences of the consumers, of the customers, the clients, and if you then are able to produce a positive hearsay and positive news and publications, the value of your trademark rises appreciably. And later on in the higher ranks, it's clearly also the performance of the company. It is the prospects. It is the fact that that the company is a technology leader and such things, which increases the value of trademarks to very high values. Yeah, then you have the already mentioned design patent, or in Europe better called registered design, for the appearance of products. So no technology inside can be protected by that, but designs are very valuable, not only in the fashions industry or let's say high value furniture and so on, designer furniture, um, but also, for instance, the car producers, they use a lot of design patenting or a registered design in order to protect their products, which are highly esteemed very often by the car buyers, just that they are copied with lower prices and so on, and this can be efficiently protected by registered designs. Here in this table, I have also mentioned two other industrial property rights which will not be covered in the afterwards, but which may be mentioned once. For semiconductors, the patenting system is, let's say, too slow because they have very short development circles, and therefore there is another form of intellectual property right, semiconductor protection, for the 3D structure of semiconductors, which is, let's say, gained a lot quicker, but also then not valid so long. And then you have the very highly and controversially discussed variety protection of plants. I may mention one name, Monsanto, where there was a lot of very heated discussion on, let's say, the ethics of variety protection, especially if farmers are then not able to grow crops from the seeds any longer because they are hybrids, and you always need to buy new seeds from this company in order to proceed. Yeah, So this, and now I want to go more in detail for patent and utility model. I deal with it in the beginning together, and I then show you the differences, but both cover and protect technical inventions, and therefore it can be discussed here together. So a patent or a utility model always are dealing with technical inventions. You have as kinds of technical inventions, you have, for instance, device which is innovative and invented. It can be an innovative process, and in certain cases, it can also be software. If it is a computer implemented invention that fulfills the criteria, especially the criterion that it delivers a detailed technical solution to a technical problem. Yeah, then what is the effect of patent and utility model? A patent and a utility model refer to a technical invention. Yeah, and the effect is it is not. It is very important to stress that a patent is never something which allows you to do, for instance, a certain fabrication of an innovative product and so on, because there may be other patents on the way which you have to, which you would violate if you just do it. Although you have a patent on your own for a certain detail of the fabrication or of the product features. So in fact, all these intellectual properties are always prohibiting third parties to do it in the same way, to fabricate it commercially and to market and sell it commercially. What is never restricted is research and development, where you just try in the lab how this patented process or fabrication works. So as long as you just do it for research and not sell it, then it is not forbidden to make it. But what is forbidden is the commercial dealing with it, so that you make money from using this technology. And there is then also an interesting feature on it, because the proprietor of the patent may, let's say, relax this prohibition for certain parties, and these are then licensees, in accordance with conditions which he himself may establish. So what is always important is that the patent owner, who normally also produces these products, for instance, on his own, has to take care that the licensee is delivering the same quality, because otherwise this would destroy the reputation of his own products. And very often it is also combined with an additional trademark license to use a trademark for this patented product, and so to sell both of it. And very often nowadays, especially from the young generation who is, let's say, used to get many things for free, or let's say it's only part of the deal that it's free. The other part is often that they sell their identity features and their behavior peculiarities to the big five of software industry, all in America, and also to others. So what is they often say patenting hinders innovation, it should be removed and everything. The most important counter argument is actually, if there would be no advantage for providing the society with a very detailed description of what has been invented, and this is mentioned in this paragraph, the invention on which the patent is based is published. So this is part of the deal with society. You get a temporary monopoly, which is normally not so well sought after. But in return, you offer us a detailed description. And why is this very important? Because otherwise, inventions would be made multiple times by multiple parties and companies if they would not know that others have done it this way, by having them patenting it and by being able to read it and to read exactly what has been the technical solution to the technical problem. And very often, from reading patents and from own experience and knowledge, you can then find even improved technology, which you very often can patent yourself. So the technical development, the fast technical development, has been fostered a lot by the patenting system. And still, because of ignorance and because of no patent searching and so on, still you have double inventions causing Europe, let's say, very inefficient spending of companies of in the range of 60 billion euro per year. So, and how much more would it be if nothing would be disclosed, because the inventor has no advantage from disclosing it. So this concept of disclosing it to society and in return getting some monopoly has even been initiated in medieval Venice, because already there the advantages of such a system have been found and shown. Yeah, going to patent requirements. First of all, clearly a patent is dealing with a technical solution, and therefore the advantage has to be achieved by technical means. The second bullet point is very important, and is what is being checked mainly by the examiners at patent offices. The technical means must be worldwide new and not accessible to the public before the patent application. So very often, especially in if companies are cooperating with R&D institutes, especially university institutes, for instance, they have an enormous pressure to publish. And if you have no good procedure, first to check whether it is viable and meaningful to patent, and only after patenting, or if it's not intended to patent right after the decision, to publish it. That would be the much better access to this topic. So, and then you have the third bullet point: the new technical means must not be obtained from the known state of the art in a manner which is obvious to a person skilled in the art. This is a bit of another description of what I have mentioned before. So you always have to go beyond the normal skills of an expert in the field. So his daily work and the skills in his daily work. So an invention has to be beyond these capabilities of experts who get this task and who could in many cases also successfully solve the task without really making an invention. So you have to get over this barrier in order to get the patent granted. And then there is also something, there must be no reasons for exclusion. I'm shortly going over this topic with the exclusions. So discoveries, scientific theories, and mathematical methods are clearly excluded from being patented. This would really hinder the progress, the technology progress, if you would be able to patent scientific theories and mathematical models. So one example which has impressed me very much in that respect is a German Nobel Prize winner has developed so the so-called giant, not has discovered, sorry, has first discovered the giant magnetic resonance. This in turn, then this effect allows to make kind of a vertical magnetization and not only a horizontal. And this led then in a technical development later on to a 10 times higher capacity of the hard disks. And here you see the difference. The scientific discovery and theory to it have not been able to be patented, but this Nobel Prize winner was also then involved in the technological application of this effect to hard disks, and this has clearly been able to be patented and is definitively one of the inventions which resulted in a lot of money intake. So other exclusions are, for instance, aesthetic creations, but they can be protected by registering a design. Then a quite relevant thing which was always or which is often faced in my coachings, IP coachings, is that clients come along with inventive ideas about business activities. So an innovative business model, for instance, would be the best example for this bullet point. And this cannot be patented in Europe. It can be patented in the US because they have a bit of a different patent law. So this makes quite a difference. Then you have this exclusion If you make pure reproduction of information, this cannot be patented. And then you have this big topic of computer programs per se. If they are without technicality, they cannot be patented, but there are a lot of computer implemented inventions out there who are able to be patented. And then there is a last bullet point, violation of good morals. So if you, let's say, would develop a poison with the target to kill as many people as possible, you will definitively get no chance to patent it. If you would patent a rifle for the with a technical invention that people can be killed from larger distances and whatever, this would also be a violation of good morals. But if you just patented it, how it technically works, how the trigger works and so on, this is still feasible. So, but it is not necessary to use this exclusion very often, I have heard, but there are some cases. So very important now is range and duration of patents. Very important is this consideration that it's a territorial right. You have territorial patent law, and the patent has to be validated or applied for and granted in the specific country. This does not mean, on the other hand, that you have to, in the first moment, patent it in all countries in parallel. As I will show you later and also mention here, you have in principle two internationalization routes, which first have a common application procedure. So if you apply for a European patent, which has nothing to do with the European Union. European patent, even I have mentioned, it can then be later on extended and validated in maximum 44 countries. I mean, nobody would do this, even bigger companies not. But if you have special reasons why you want to have it also in Turkey, then you can do it after getting a European patent granted. So this European patent is divided into individual national property rights after grant, and the applicant may choose in which countries of this European Patent Convention the European patent shall be valid. So here it was given 2014, it were 38, but nowadays they are, with the extension states, they are even 44, because nowadays even Cambodia can be reached on the basis of a granted European patent. The important thing to consider is, as long as your patent application stays in the European phase without already being granted, but also not, let's say, cancelled, then there is not so many, the annual fees are not so high, and you still have a foot in the door. But as soon as you have a patent granted, you only have 1 month to decide in which countries you want to have a national patent, and then you normally also have to provide translations The only, but very important exception is there has been a London treaty which regulated that if the application language is English, German, or French, then all the countries which have one of these three languages as their national language, for that countries you don't need a translation anymore. Only the claims are translated in the two other languages. But if you, for instance, want to extend your European patent to Poland, Czechia, Spain, Italy, then you have to provide a translation. Yeah, and if but in case that somebody starts a lawsuit, for instance, with the remark that this patent should be nullified because it is, the technology is either not new or not inventive and so on, and he has good arguments for that, then the lawsuit will be covered by national patent law. So the maximum durations for duration is nowadays in practically all countries 20 years. In contrast, it's only 10 years for utility models. But first of all, utility models do not allow such a streamlined internationalization process because they are not available in all countries. And secondly, this I will show in the next thing. Secondly, if I continue here, the protection of a utility model is low because in most countries, utility model applications are not examined. This especially holds for China, which has millions of utility model applications, and in most cases, initially you don't know whether this is legal, whether this is really a valid intellectual property right, or whether it would be nullified anyway if it would be contested. So generally, this comparison of patent and utility model, I will start now again at the top. For both, novelty is required. But as I have said before, for the utility model, it is not checked at the application stage. A very interesting thing about utility model is that you have a 6 months grace period. So if there is such a case that you would normally have good chances to get a patent because it's new and inventive and so on, but one of the partners in the consortium has published it already, then you still have, as the IP owner, you still have this 6 months grace period to register a utility model. Both need a kind of inventiveness. For the patent, it's considered a bit higher, the level. So you need here an inventive level, whereas the utility model law speaks about inventive step, which is considered to be a bit less of a demand. So the procedure for patent is longer and for utility model is shorter. That clearly also has to do with the examination, which quite often is not taking part. I mean, Austria, for instance, is one of the few countries who also examine utility models, but then they register it irrespective of whether it is new and inventive or not. So this always has to be then contested by those who are confronted with such exclusion or with let's say an intention that they should stop producing it because the other has a utility model. Duration I've always already covered, and the costs, I mean, the office costs are a bit higher for patent than for utility model, but I would not consider this to be a very important difference. And anyway, the patent attorney costs are significantly higher than the office costs. So therefore, this is not really so strong of an argument. Then we have registered design, in US also called design patent. So again, it's only possible to protect what is visible and depictable by a photo. You need as prerequisites for granting novelty and individual character. Here I have also included for you a link how you can find registered designs which also cover US design patents, for instance, in this European database reached via Design View. Examples here are, for instance, this Lamy writing device and or a designer stool, or such a structure on floor plates. These can all be protected by design patents. So for design registered designs, as has been said, novelty is needed, but the let's say the kind of novelty or the stringentness of the novelty is by far not the same as of the patent. So it must not be known to the public before registration, but restricted to a certain market area. For instance, to the country where you want to register it. So theoretically, it can be known in Germany, but if it is not really known in France or in Italy, you can get a national design registrations in these other countries still. I have already mentioned that the grace period is 12 months. If the disclosure is done by the creator or a legal successor, this can be used very efficiently, for instance, for designer furniture and so on, but also for other topics. If you show them in big exhibitions and so on, and then check whether they find interest of customers. And if you do not find this interest, you may just have it waned out. And if you see that there is an interest, you can still register for a design within 12 minutes before showing it the first time. So, and this is also covered with the relative novelty, what I've said before. If it is design was accessible somewhere in some other country before the priority date, but could not be familiar for experts in the European Economic Area in the course of business, design protection could still be claimed. Yeah, and here you have this registered design individual character. So it has to be something special and not that customer says, such a kind I have seen already here and there and so on. So then it would not fulfill this requirement of individual character. What is the effect of registered designs? It is a bit similar to other intellectual property rights. So third parties are again prohibited from making, offering, or using products which are similar to the protected product in a manner which is okay. Sorry, this was a duplication. Um, um, So, and then the property right owner may again go for a design patent or registered design license contract where he describes under these and these conditions and for these and these license fees, you may also use, for instance, or you may also produce this designer furniture. And also the design is published and can be, for instance, looked up via the design view search engine. The validity and is described, temporary validity is described in that way that the maximum duration you can extend a registered design to is 25 years, but you have to pay a renewal fee or to initiate renewal every 5 years. So this has some end then, but normally designs are also not valid that long that you really want to pay for it longer. And one thing which is worth to be mentioned, priority period. The effect is the same as with patents, but the priority period is not 1 year, only 6 months. So within 6 months, for instance, you have to decide whether you want to internationalize your design application. And I will show it later on with which features. So for trademark, we have this thing that you can, so 4 different kinds of trademarks are depicted here. You have on the first, in the first tag, you have this word mark, for instance, Mercedes-Benz, Volkswagen, or Bosch or whatever, or before Nokia. This was also a word mark. Then you have a figurative mark where you have only graphics. I suppose you know this famous figurative mark. It's from Nike. And then you have a combined mark with word and graphics. And in this case, it was for me at the time of setting it up also interesting to note that the very renowned company Nestlé, the Swiss company, has really a bird's nest as a graphics inside in this combined mark. So combined marks are also considered as logos. And so if you want to register a logo which comprises not only text but also a strong graphic, then you go for a combined mark. And then there is something special. This is a 3D mark. And here the 3D design can be protected. You may argue why here a trademark, because normally It could also be protected by registered design, but as I have mentioned, registered design runs out after 25 years at the latest, and Coca-Cola bottle is on the market much longer already. And if it is not a technical reason why the shape is like that, you can use a 3D mark. So trademarks, first of all, a very important thing is that all graphically representable characters can be trademarks. So you have to provide it in a form which can be seen and which can be documented by a photo, for instance. But this comprises also melodies or songs because or signatures because they can be represented by a noting table or the noting description. And then you should consider trademarks as distinctive features for goods and services of companies or for the companies themselves. And a brand contributes strongly to the company value. Regarding the acquisition of a trademark right, there is the possibility to get it even by use, but I would not really count on that, because you need a reputation then for a large share of the market participants. So it's a bit different in the different countries and so on. But sorry, could you please shut off your mic? And there is a reputation for a large market necessary. So we are speaking about, for instance, 50% of the market should know this brand. And this is normally not possible for smaller companies. And the big companies anyway go for the more reliable registration. So it's anyway better to register it. And for registration, this can be done by the National Patent and Trademark Office, as it is normally always combined. And before you do a registration, or also to check whether your use of a certain name or whatever of a certain word for your company or product is not already protected, you can use this search engine Trademark View. You here have an overview of, let's say, at least a lot of countries also outside Europe, clearly all European countries, and a lot of countries also outside of Europe. I would say the most important are contained. And protection is achieved by registering a trademark. And clearly, this is a much better proof that you are the one who has registered this at that moment, and this is a much better base for a legal dispute. There are quite some reasons for exclusion from registration. I mean, colloquial terms, for instance, special words in a special dialect, they cannot be registered. Geographical or political names or even national flags and so on cannot be registered. What is much more important, and this is from all the bullet points, the one who is violated or at least tried to violate at most are descriptive terms. For instance, Styrian honey, or just trying to register something like car wash, because there are 10,000 of other car washes who also want to say that they are car washes without violating a trademark, and therefore the offices do not allow descriptive terms to be registered as trademarks. And then exclude there are also fully common names, for example, internet or yeah, whatever. There are a lot of such things. And a special thing is also the 3D shapes. I have mentioned it for Coca-Cola, but there it was no technical function. But for instance, Philips has this three head erasure, and they wanted to get the 3D shape, but the argument against it was that this has a technical reason why why the form is like that, the design is like that, and therefore it cannot be protected as a purely aesthetical design. The effect is quite similar as to patents. So a brand represents an asset. Maybe this feature is even more prominent because for most companies, brands are even valued higher than patents and so on, except some special cases of technology companies. The brand can be used to achieve a unique selling proposition. Third parties are prohibited from using the same. So that's similar as for patents or design registrations. And the trademark holder may loosen. So again, the trademark license contract is possible. And validity and priority is so again, the property right is a territorial one only in the country in which the trademark is registered. Alternative is a European Community trademark, which has a very favorable price, considering that it is valid for some 25 countries, because not everyone is there, but most of them, and clearly UK not anymore. And the maximum duration is unlimited in this case. You need a renewal every 10 years. Priority, same effect is same as with patents, but again, as with registered designs, priority period is not 1 year, but only 6 months. And now I just show you very shortly. You can then check it yourself, but I set it up freshly with the most recent information I could find the last couple of days. You find here the brand rankings just shortly. On number 1 is Apple. Number 2, Google, and then Microsoft, Amazon. So you find the first non-US company is the luxury brand company Louis Vuitton Moet Hennessy from France. And then you have already Alibaba. So really very shortly, you have here a depiction of the top 10 brand corporations USA. I used here the 2019 because the other one is a very long table, not so nice graphics as this one. But you see here, for instance, the increases in value are appreciable, especially for Microsoft, Amazon, Google, but also Apple had this increase. Then you have the top 10 Europe brand corporations. This Louis Vuitton Moet Hennessy is leading by far. Then you have Nestlé. You have a beer company on third place, and Unilever on third. The brand corporations in China catch up a lot. Nowadays, they have 12 brands in the top 100. They have rank 4 in the big economies, and they have a share in the top 100 of about slightly above 10%, with Alibaba leading the field in front of Tencent and Huawei. So in Germany, you had some changes. Volkswagen, when the diesel scandal was really hot, they were not on first place, but then they catched up in 2020 with 18% increase and are now on number 1, followed by Telekom and SAP and Daimler and BMW and BASF. So this is the last slide I would like to show you, where you see that from another source, which is also accessible by this link, that the brand value by country, the leading country is Germany with some 25%, France 20%, UK some 18.5%. And quite interesting also, the brand value by sector is you have automobiles in the lead, followed by banking, retail, telecom, apparel. So this sums up my module here, and I would say we have deserved some pause. Maybe if we can shorten the pause a bit to catch up with the later start, I would like to propose that we start in some 11 minutes, so at 10 minutes before 11. Thanks a lot for your attention up to now, and I hope you already have posed some questions. You still have time in the second half, but my colleague will be happy to summarize your questions and depict them then at the end for a Q&A session. Thanks a lot and enjoy your pause. The 2 modules well. This module funding options has actually been initiated by one of the participants who asked whether I will also cover funding options. At first, I have not planned it because it is very different from country to country. But then I've found some way how to deliver you information which is valid for all of you. So, as I said, patent cost funding is quite different nationally. You have, for instance, patent cost funding in quite some countries, at least I have not checked it statistically, in national R&D projects. So quite often costs for patenting are eligible for project cost summaries. And my advice here is please consult your regional and or national funding agency, because they will know best. In Austria, it is the FFG or Forschungsförderungsagentur or research funding agency. But I don't know in each country clearly, but you will find out easily. So as I said, patenting costs are often eligible to be funded as part of project cost. Yet there are differences between kinds of project I have observed, at least I checked it in some countries. Quite important very often is the technology readiness level. I have inserted here a link to the definition of the technology readiness levels, which were originally developed by NASA, but nowadays also used very much in Horizon 2020 and Horizon Europe, for instance. You have to take care that double funding is not possible, and that you should choose the better funding, or sometimes you can, if you use a good timing, you can first, for instance, as an example in Austria, you can first apply for a patent voucher, which gives a very high funding rate of 80%, but only after the patent office, which is also then funded for 80% this cost, but only after they give green light, then the further costs of a patent attorney and office costs are funded by 80%. In projects, the funding depends very much, but for instance, in some projects you have 50% funding, and clearly it is better than to go for the 80%. But if you in Austria first apply for a patent voucher, you still then can apply for a bigger project and get the funding, whereas and still have this funding of the patent voucher. Whereas the other way around, if you already have applied for a project, if you have been granted the project funding, and if you have started the project and then apply for a patent voucher, this is not possible. So general, and I will depict this later, a very good hint would, I think, very helpful hint would be to ask the IP help desk ambassador or EN office next to you for advice. I will come to that later. And links and info on that are below. But first, let me depict just this one thing of Austria as one example, this patent voucher, which has fostered actually patent applications by startups and SMEs profoundly. So the maximum funding is 10,000 euro if you have cost beyond at or beyond 12,500 euro. And clearly there are some conditions to be observed and criteria, but in general, it is available for small and medium-sized enterprises even before they have been founded, but they should be founded then before a patent is actually applied for. In Germany, I found that there is not such a nice funding, at least I did not find it. But here is the type of fees for every other things, because I just made a screenshot of this website, which you can access via this link. And important is here, the annual fees in Germany will be reduced by half if a declaration on the willingness to grant license to anyone is made. So this is, I think, an interesting approach, that they want to foster technology transfer by granting, by having companies granting licenses to others and by declaring their willingness. Then, as an example of European projects where you get patent cost funding, I have searched for this Horizon 2020 annotated model grant agreement. At least I could not yet find one for the Horizon Europe, but it is soon available, I would say. And here it is said that costs related to the protection of the action's results, for example, consulting fees, but also fees paid to the patent office for patent registration, are eligible if the eligibility conditions are fulfilled. Costs related to protection of other intellectual property, for example, background patents, are not eligible. So background patents means patents which you have applied for before you start the project, because therefore it's then background IP, which is quite important also to mention it correctly in the consortium agreement. But clearly this is then not covered by the project funding. And now I want to introduce you to this network of IP help desk ambassadors. First of all, the IP help desk or European IP help desk is a very valuable source of information and of online trainings and document IP documents, guides, fact sheets, and so on. And the ambassador scheme comprises currently 47 ambassadors from 28 European countries. You see it depicted here. So, for instance, even Estonia and Lithuania, where we have also participants from Lithuania, are covered. Let's say practically, okay, you have not in the team Sweden and Norway or Switzerland, but most of the others are contained. So you have this link here, but here I have included also a link to the ambassadors team. Without much further words, but the one in the left upper corner is me for Austria. But you see that you have from Bosnia-Herzegovina, Ireland, Belarus, Bulgaria, Italy, Croatia, Belgium, Denmark, Germany. And these are not all. I just made some screenshots to give you some, or Estonia, for instance, my colleague from Estonia. So they are really experts in intellectual property. They also will know very well which national funding is available, or even international in EU projects. So these are definitively good contacts to get free of cost and profound support. On the other hand, and I have to say there is a connection between the two, because every ambassador is also member of an Enterprise Europe network team in his country or his region. And here I have depicted or included a link to the Enterprise Europe network and to the countries. This is just a split screenshot or combined, because it would be a long list. But you can find like that the country you are living in, most certainly, or practically certainly. And if you, for instance, take out one like Lithuania, you can that, sorry for for a quite small screenshot, but it only should depict, here you have Lithuania, and here you have 5 cities from Kaunas to Vilnius. And here you can double click on the city nearby your office, and then get also the support you need. Sometimes they may even refer to the IP help desk ambassador. Sometimes they have enough own knowledge about funding options, because funding is actually one of their mainstays, so should be possible. And then I have also included one thing which is accessible for all of you who are in the European Union. I have to restrict, suppose, because this is offered by the European Union Intellectual Property Office. And the link is again given here. And in general, I would say the European Union Intellectual Property Office is institution which you should know and also use their services, because they are actually responsible for all European Union trademark applications and protected or registered designs. So they have their headquarters in Alicante, Spain. But nowadays, it's not a problem to access the services from everywhere via the website. They are also running very important search engines, which I have mentioned already, like TM View for trademark search and Design View for design search. And what they are doing now is since some months, so since this year, they offer a very interesting, a very attractive funding of trademark and design applications under the umbrella of the SME fund. You can find more information in this on this website, and you see that, for instance, what I have proposed you to consider if you think about applying for a trademark or a design protection is this 50% off of these fees. And each SME can be reimbursed up to a maximum of 1,500 euro. So if you are reimbursed up to a maximum of 1,500 euro, clearly this means that you should apply for, if you want to use it fully, then you have to apply for more than one trademark or for trademarks and design registrations, because the normal value or the normal cost of a community trademark, as it is also called, is some starting from 850 euro for one NHTSA class, going up to 900 for two NHTSA classes, and 2050 for three. Normally, you need only one class or maybe two classes, but originally also for the community trademark and for the national trademarks, it was usual to have for the same basic fee already three classes. So my let's say advice would be to consider one or two is probably sufficient. And if you look for how to find the correct classification, you can use TM class, but you will find all this if you double click on the EU IPO logo. You will find all this. So this is my advice. If you consider after especially also this IP awareness workshop that you should apply for a trademark or for a design, then please use this fund. It is only important to note that this funding is first of all ending with end of September. At least the current stage of information is like that. And you always have 1 month in between where you cannot apply for it. So either you use, but you are perfectly in time still. either you use July 2021 or you use September 2021 to apply for this. You can use this website for it, but also some offices, some national offices are offering own websites which are based on this funding. And then if you apply for it in July or September, you will be able to get a refund till the end of the year. So this sums it up for the funding. If you have additional questions, please post it in the chat. And I will now go to the next topic, and this is patenting strategies. So in here, I would like to introduce you a bit more in detail to the procedures, how to apply for, and also some other considerations. In the following, I depict the patent phases and what is important in each stage. So you have this phase before the application. This is the invention phase. Here it is very important to obey secrecy or to use at least a non-disclosure agreement with somebody. You have to tell this, for instance, to some manufacturer of prototypes. It's very important to use a non-disclosure agreement. In this phase, you will also have to do patent search regarding novelty or have it done by an expert, for instance, somebody at the Enterprise Europe network or the ambassadors. And then you also have to consider economic potential to be scrutinized. Is it worth the investment in the patent costs or not? And then clearly you should give an order to a patent attorney to take care of it, to the application. After you have applied it, the patent application, it is in principle communicable because you have this clear priority with your document at the patent office. You can then or think about with whom to cooperate for utilization or for exploitation. Most of the time, companies still have to make some product development in this phase, and you get normally before the end of the priority year, which is a very important year to obey, a very important phase to obey. You get the search report, and you can then, together with the patent attorney, decide whether it looks promising, and you may then go to an international application, or whether it will be very difficult. After the priority year, no international patenting of the original idea is still possible. So everything what you do afterwards will not be granted, because your own first application will then be novelty destroying. So you have to do international applications within this 1 year. Very often you do it, and this is given here, very often you do it as a European patent application or world patent application by the Paris Cooperation Treaty method, so PCT application. A granting will last from, let's say, 1.5 years to 5 years, sometimes even longer. In European phase, it is normally some 3 years, maybe 4 years, but you can even ask free of cost for a shortened examination period. And then you have this national validation or unitary patent after the EP grant. And here in this phase, you may face significant cost, for example, for translations. And then you have a maintenance phase where the fees first are quite low. In Austria, we even have a period free of annual fees in the first 5 years, and then it gets more expensive from year to year. This is also a good regulation, because something which is not worth the somehow increased annual fees should be given up. And those developments who are really attractive also for customers and so on, they will easily pay the increased fees. So withdrawal is then also possible at any time, and cost will be stopped immediately. You can also, if you first, for instance, had a European patent application, you have been granted the European patent, you have then, for instance, validated it in some 6 countries or 8 countries, and you find out 1 or 2 of them are not performing as you have intended, you can easily stop those national patents and still have the others going on. And for this whole phase, after priority year, an exploitation is important, either yourself, or you can also maybe additionally find a licensee who pays you some license fees and who takes on this technology and improves the coverage of the market. So these sheets, I will go over them because they in fact describe what I have just now explained on the basis of these graphs. So please allow me to skip them because anyway you have heard it before, but if you want to look it up again in more detail, you can find it here. Maybe just here, this remark, official patent search, a search report, clearly it's also depending from patent office to patent office. In Austria, you get the report in between 7 and 10 months. Normally, let's say roughly mean value would be 8 months. And this is an important decision support and the basis for amended international filing, or maybe in some cases also to drop it because there were novelty destroying documents found by the examiner which you cannot overcome. This may also happen. Okay, so then you have, for instance, what I have already explained, these international patent applications, European patent or PCT patent applications. With PCT, you in fact reach some 152 states, practically all relevant states. But this does not mean that you have to afterwards to nationalize it in every state. It's just a chance to decide 1.5 years later after the PCT application, which countries should I use, or for which countries should I nationalize my patent. And so you have in total from the from the first application in the first country, the so-called priority date. You have, if you use it, and normally a patent attorney uses it fully, you have some 12 months for that, and then additional 18 months for the PCT phase. So only after 30 months, you then have to decide in which countries do you nationalize it. And yeah, and here it is said, for a suited international patenting strategy, an IP expert should be consulted. For example, yeah, here is again a third thing which I have not depicted graphically, but beyond the European IP Help Desk ambassadors, beyond the Enterprise Europe network, you also have quite surely local PATLIB centers. These PATLIB centers are supported by the European Patent Office and provide you also local support. So you will find these PATLIB centers in this directory via this link. Yeah, and then I think we have spoken about this. I just realize theoretically possible are nowadays even 44 countries after EP grant, but some of them are not very usual to be used, like Morocco and Tunisia and Cambodia. So in fact, the 38 are still more relevant. Yeah, and then you have this topic of the maintenance fees. For instance, in Austria, 5 years free, then starting with 100, but that in the last year, for the last year of the patent duration of 20 years, you already paid 2,000 euro. And it is roughly the same in other countries, but there are differences clearly. Yeah, and this shows a bit the coverage of EP patents. So you have here the 38 states, as I mentioned. You have 2 extension states, Bosnia-Herzegovina and Montenegro, and you have 4 validation states, as I mentioned, Cambodia, Moldova here, and Morocco and Tunisia. So Tunisia here and Morocco here. Here I want to give you some impression of the international patenting and the timeline of the European patent application. This, for instance, is one of the IPR documents available via the European IP Help Desk, the IPR chart for European patent. And here again, you have what I said in between also a bit already. Priority period 12 months. You have in between here, you receive a search report, but and then you have an examination report. So in the European patent application, you really also get an examination, and if it's positive, you get a grant. Whereas in PCT, you get no examination, you have to go for national procedures. And here you then have, after the grant, you have 3 months to decide in which countries, so this 44 or let's say 38 and the rest not so important normally, you have this validation, and you also have after grant, which lasts for about 3 to 4 years, you have a 9 months opposition period. So this is longer than in many national procedures. And in this 9 months, it is possible to bring along good arguments which have to be considered then by the examiners, without really paying. So it's just your time. You nowadays you even have let's say software means to do this. You don't have to write the letter. You can make some opposition thing directly in the software or in the website of the European Patent Office. And so this is quite good. In contrast, or let's say not in contrast, here is again a bit of another, so I don't have to go in detail on. This is just another source which I used, and I have here corrected it to, in principle, even 44 countries. After granting, you can go to that. What is probably more interesting for you is a consideration of the cost of the European patent. This is a study which is already quite old, but I would not say outdated, because you may consider some increase, but the principles still are valid, and there is no more recent study with such nice depiction of the results. So for the European patent, within 10 years, at that time it was around 32,000 euro. Now you probably have to think about 35 to maybe even 40,000. But the principles and what the cost contributions are stays the same. So you have the fees of the patent office, which are around 14% or 4,600 euro. You have the validation in the contracting states. So here is an example that you need 4 translations, because you don't need for every state. So this is an example of 6 states. I have forgotten to mention 6 states. Here I have mentioned it. So you here have also appreciable costs for the validation, be it from for the attorney, be it for even higher the translation cost, and much lower the publication fees. You have then the annual fees. These are the national renewal fees. And here it was considered from the 5th to the 10th year. So till the 4th year, it was in the European phase. And here you have the other fees of around 10,000 euros. So this is also appreciable. And clearly the professional representation by the patent attorney, and you need an attorney with a qualification as European patent attorney for this, is also to be considered. In comparison, you have the cost of a PCT patent, also 10 years validation here in 8 states instead of 6. So this is one reason why the cost is higher. And I don't want to go into detail. This is the same scheme again. The office fees, validation fees, renewal fees and related costs, and professional representation. And this is some 40,000. So now I would like to switch to some strategic considerations. So strategic patent management, clearly this is even more important for big companies, but also as an SME and startup, strategy is a good thing to consider. Because patent strategy or strategy in general means to have a long-term oriented planning of an advantageous position. And in this realm, you have to think about 1 or maybe even 2 or 3 patents. if they are really strong, or if they protect commercially interesting innovative technology you have developed, then they really bring you into an advantageous position, be it for investors, be it for cooperation partners, be it maybe even for licensees. So this is then something which is also very important for SMEs. First of all, you should consider safeguarding of a unique position in the market is something which should be established. And one can say that especially for startups and SMEs, investors always look for patents to protect the unique position in the market, maybe best accompanied also by 1 or 2 or 3 trademarks. A leadership in technology, design, or market presence is also such a strategic goal. Clearly, for a SME, leadership can only mean in a quite narrow range of or detailed technology, but there it is also important that you have kind of a leadership. Then also this is maybe a bit more leaned towards bigger companies, that the R&D is at least partly focused on patents, so that they have the goal to stake their claims in a certain technology areas by profound and good patents, and that they focus the R&D also to this, because this allows a strategic patenting in own technologies. Then you also should be aware of activities of competitors, and early indication can be gained via patent searches. On the one hand, you have to consider that you do not see patent applications normally before 1.5 years of after registration. But on the other hand, the market entry of innovative products based on these patents is even later. So if you from time to time check the patent situation and the patents of patent applications even of competitors via patent searches, then you get an early indication that maybe such a innovative product will enter the market in the next 1 to 3 years. There is a whole bunch of technology nerds who are following all patent applications, for instance, of Apple or other technology giants, in order to imagine what products may be next on the market. And then you can, apart from patents, you can also use registered designs or design patents and trademarks as additional intellectual property rights for gaining unique selling propositions. And you can thereby increase your company value and or your creditworthiness. And this is something that is again very important for SMEs or startups, that patents really make a difference also in getting financing. So for the strategic patent management, you should also later on consider the option of licensing or even sale of IPR as a source of income. this is particularly interesting for SMEs as they are not able to cover the market with high numbers of products or services, and therefore licensing may be an interesting option. So preparation for negotiations and agreements with competitors. This is something which again is in the higher company sizes more important. Cross licenses for respective barrier patents and patent pools. But also SMEs can consider patents and other intellectual property rights as versatile assets, meaning that they can use it either for licensing or for attracting financing, or any other, or for demonstrating that they really have a leading position in this very detailed technology. So what is also important to have some strategies for the protection of company know-how. You should for all means consider secrecy. So especially you should also not patent if you are not able to prove that some patent infringement is taking place, because then it would only be a manual for others how to make it without position for you to then forbid it. Or if a disclosure would be too critical because of circumvention, which is possible. But the danger when you keep it secret is that the competitor may file a patent, and then you at least have to have a very good documentation that you can prove that you really made it already before he patented it. And therefore, confidentiality agreements with partners are often valid. For instance, they are necessary with suppliers, but even more so with prototype manufacturers, because you can consider that they would be the ones in the best position to be fierce competitors if you do not use confidentiality agreement, because they can manufacture, they have the knowledge from you how in detail to manufacture it. So this is very dangerous if you don't have a confidentiality agreement. And patents and other intellectual property rights provide a stronger protection, which can also be better used in law disputes, because you have a very good proof of what you have had at what time. And clearly it is also suited for own utilization or for exploitation via licensing. So this ends up my presentation. I have now saved some minutes. I hope you agree that we should proceed. So my colleague will then present the Mentimeter questions, and which are very valued for us. So therefore, please give us this feedback. And it is also interesting for you in the second part. You will insert specific words you have imagined, and then you will see a word cloud what others have said. So this is then also quite interesting. And after this feedback, I will turn to the summarized questions you post in the chat, and I'm happy to answer them. So I will then stop my sharing of the screen. I would like to ask my colleague to take over, and so please use either you scan the QR code or you use the link, which is I think Bettina, you will provide or have provided it also in the chat.
I will post it now, so
Okay,
it's
okay.
easy, I think.
Yeah, exactly. Please post it and then change to the question to the Mentimeter questions. So you will find now the link already in the chat, and the first question we would like to have a feedback from you. Sorry.
That's the word cloud.
Huh?
The question is not visible for
Sorry.
everybody. That's the word cloud.
Okay. But the word cloud, I think we will do afterwards. Yeah. So please use the link, and when you have used the link, you get these questions, and please answer them. They are a very valid feedback for us, also for project documentation. And once again, I may offer you, but sorry, only for those of you who are beneficiaries who have received a grant for their project proposals, that I can offer a one-to-one detailed IP coaching corresponding to your very needs regarding IP, or specific hints and suggestions what to do. So I'm happy if I receive mails, because you have my contact data either in the presentations or also before. And the presentations will later be, so they are recorded, and they will be then loaded up to a YouTube channel, and you will receive the link later on. Bettina, have you checked, or can you check whether the questions have been answered by those still participating?
I just see how many already done it, and that's 3.
Okay, cool. So to at least what I see here, 2 others would be fine if they could also give us their feedback.
Would you go back to the questions for now?
Yeah, you can do it, though.
Yeah, but then I
Yeah,
back.
please go back. Yeah. Mm-hmm. So not showing the results, just the questions. Yeah. So once again, please, if you have not yet answered the questions, we really appreciate if you still do it. Because then I'm more motivated to respond to your questions. Okay. Bettina, so you have already now posed the questions to me. Yeah, let's go to that. Yeah. Anyway, if anybody still gives some feedback, we will be happy. So first of all, the question was, how does one prove that an invention is obvious to a person skilled in the art? Actually, you have to distinguish between two parties. Proof is also maybe a bit of a strong word. The examiner is often, let's say, assuming that this invention is obvious to a person skilled in the art from his overview, from his very detailed knowledge of the technology, because examiners are chosen at the patent offices always according to their technological background. They are always educated in science, technology, natural sciences, something, and their legal education is only on top of it. So therefore, this examiner can judge it, and then it is very often a dispute of arguments between the examiner and the patent attorney, because the patent attorney clearly already at the beginning, at the application, is trying to depict it in a way that he demonstrate this is very innovative, this is even surprising, whatever. Yeah, so they use some wording like that, but clearly the examiner is then checking whether this whether he buys it. Yeah, and so it's a quarrel of arguments, I would say, quite often. And the second, I hope this answers the question. So, or let's say I give you two more hints. If something is quite usual in nearby technologies to combine it that way, and yes, the combination is in that case new, but a person skilled in the art could have learned from the other examples of nearby technologies that this is a good method, then it will be obvious to a person skilled in the art. So, for instance, if somebody invents a new drive possibility for opening a garage door, yeah, and the one does it, for instance, pneumatically, and the other with a diesel, and the third with whatever, with a gasoline engine or electric. I mean, these changes may be new, but they are quite obvious to a person skilled in the art, knowing also other topics that they could be used as an alternative. Then I may turn to the second question. Does the SME fund also cover patent filing costs? Clearly, no. Because first of all, the European Union Intellectual Property Office is not dealing with patents, is not responsible for patenting. This is done in Europe by the European Patent Organization, patent office, but they are not really a European Union, or they are not at all a European Union organization. They are a multinational organization established quite long ago in the European Patent Convention. And as I've said, 38 more or less core member states, and then these 6 new states are covered by this. So the SME fund is really concentrated on trademarks and things. And for patent funding, I have explained in the presentation on funding that there are multiple possibilities, but depending very much from the country procedures and also from the type of R&D project, how to cover patent filing cost. Coming to the third question, if I understand correctly, withdrawal of patent protection in a country is possible, but addition of a country in, for example, the maintenance phase is not possible, right? Yes, you are totally right. Later addition of other countries is not possible, but for this purpose, especially the PCT application allows these additional 18 months for deciding which country should really be chosen for a national patent. And therefore, you're right, later addition is not possible. Withdrawal is always possible with immediate effect on the cost, which are then zero. So quite often it is observed that either for the European patent application process after grant, you may still have more countries in, but rather soon, I have observed very often, rather soon, a lot of countries are dropped. Yeah, they are not considered for national patents. And very often you have, for instance, only the big markets, the big countries like Germany, France, Italy, Dutch, Netherlands is also quite often included, that they still uphold this, and clearly also their home country if they are not of one of them. Yeah, you have to take care. You cannot later on add a country. So I would say if there are no more questions, thanks.
Wait, there's one more.
There's one more. Okay, fine. Yes, yes, perfect. How can a patent infringement be proven? Especially for a startup SME, it must be difficult to, first of all, keep track of upcoming technologies with possible infringement, and to legally defend its position in terms of financial costs. Okay, this is a very good and valid question. Let me answer it piece by piece. How can a patent infringement be proven? Let's say it really depends on. For instance, you can more easily prove the infringement of a device patent. So something which you can detect if you at least demount the whole thing, if you look at the pieces, and there you will find whether, for instance, your type of spring or your way of connecting the things or something like that are used. This can then be proven quite easily. It is much more difficult for process patents, but even there, uh, you have a possibility if you can, for instance, convince a judge that the process patented by you has to be used in order to get such a product out of it. Um, for instance, in steel making, for instance, I mean, this is maybe not a good example for you, but there you always have quite delicate processes. But on the other hand, if you have found out that you need certain temperatures to reach to certain states of the steel morphology afterwards, and you can have a good argument that this cannot be possible otherwise, then you could even have a judge asking the possible perpetrator to show an independent person that they have an own process, or that they use your process. Yeah? So that's for the first part. And then, especially for a startup SME, it must be difficult to keep track of upcoming technologies with possible infringement. I would answer it as follows. I would anyway look either yourself, I suppose, after you have attended my second IP webinar on patent searching, you will already be in some position to check in your very technology field whether there are new applications. Because clearly also the patent office is looking at it, whether there are new things, but sometimes there is some blurring, and you should be aware of who is patenting what, because then you can stop the patenting at least in the opposition phase. Yeah. So you can avoid the granting of something which is very similar to what you have patented. On the other hand, if you have not patented, you have to look at what others are doing. But let's consider you have patented it, and to keep track of upcoming technologies. I mean, one thing is also sure, it will probably make no really sense for a startup to file a patent in China without any chance to see what the Chinese economy could maybe be doing with it. But in the European countries, you have better chance to look at exhibitions, to look at such things, and to see who is offering what. And very often such infringements are detected at big at such technical exhibitions and so on. And so there you have quite a good chance. And legally defending your position, this is definitely a topic, but it also depends. When you have a good patent where it's not easy to argue that this is not really applicable to this case and so on. So when you have a good patent, even larger companies have some, let's say, are impressed a bit by good patents. And sometimes, I mean, in some countries, you may even get some support by some funding agencies for such a purpose. In Austria, we have it with the Austria Wirtschaftsservice, but it's not available everywhere. And sometimes even a strange situation occurs that there is something like a white knight. So another big company who is stepping in, either buying your patent or taking a license and fighting against his competitor, his large competitor. So even that is sometimes possible. Yeah, I hope this has answered your questions. And I also hope that you have taken quite some things with you, as I already also see in your words you depicted in the word cloud. And I wish you a nice further day, and you will be informed and send links to the presentations and also to a recording of this IP workshop. Thanks a lot. Have a nice time, and I hope I see the one or other of you for bilateral detailed IP coaching.